Great. Okay, well, thank you. So I'm going to ask folks to, we do seem to be having some ambient noise from behind people's audio. So I'm going to ask folks if you can please silence your mics. I see a couple of folks who are unsilenced, although it does seem that we've lost some of that ambient noise going on. Okay, yeah, that seems to be working. Well, I think I'd like to call to order this meeting for November 16th of the task force. And Katie, if you would go through and do a roll call, please.
Hello, everyone. Let's get started. Kimberly Kirby let me know she was going to be late. Do we have Leslie Chambers? Catherine?
Here.
Lieutenant Kyle Hanna?
Here.
Thank you. Ramona Harris?
Here.
Thank you. Francis Abbott?
Present.
Thank you. Shannon Derman? Okay. Sunny Funk?
Here, present.
Thanks, Sunny. Rutha Chatwood, yes, we have you.
Here.
Thank you. Ashley said she is on a call, but she's here. Rachel Mayu,
Here.
thank you. Mariah Wineski. Sandra Starr.
Here.
Hi, Sandra. I am here. Dolphinette Martin. Okay. Tiffany Simpson.
I'm here.
Thank you. Remy Starnes. And Scott Payton.
I am present.
Thanks, Scott. Great. So we do have a quorum.
Great, thank you, Katie. So I think the first order of business is the adoption of the minutes from the October 19th meeting. Do I have, has anyone had a chance to look at them? And are there any questions or concerns or comments?
I'll make a motion. to adopt.
Thank you. What the motion would be to adopt those minutes? And do I have a second? Anyone want to second that?
I will second that. This is Ramona Harris.
Thank you, Ramona. Okay, the meeting minutes from October 19th have been adopted. So today, thank you all for being here and making this meeting. Today, we have for our guest speakers, a few folks. The first folks that I want to introduce are colleagues of mine with the Women's Prison Project. We have Professor Kandkar and Professor Moroz, who will be talking to us today about some of the legal issues that are facing defendants who are survivors of intimate partner violence, or another way of saying it, criminalized survivors of intimate partner violence. And we will also be hearing from Sandras Starr, who is one of our task force members from VOTE, who will talk about her personal experience through the legal system and issues and challenges she had being a survivor of intimate partner violence as well. So Professor Kandkar is the director of the Domestic Violence Clinic here at Tulane Law School, as well as a co-director of the Women's Prison Project. And again, Professor Moroz is a one of the supervising attorneys in the Women's Prison Project, also working exclusively on cases involving criminalized survivors of intimate partner violence. And so I'm going to, obviously they have a presentation, but we also, of course, want to be opening it up to questions to them as much as possible. So please feel free to, ask them questions. But I will turn it over to Professor Konkar and Professor Moroz. Thank you so much both for coming and participating. And then I believe Sandra Starr will be joining us, at least in that capacity, as our speaker a little later on.
Hi, everyone. Thanks so much for having us. I'm just gonna share my screen so I can show y'all a PowerPoint.
While he's doing that, I'll just reiterate, I would encourage folks to ask questions. Maybe Catherine and Katie can help sort of monitor if people have raised hands or something, because we do want to make this, it's sort of an overwhelming task to think about which topics to choose for a presentation like this. And we want to make it as relevant as possible to the group. And so if folks have questions, we want to answer them and make sure we're getting to the issues that feel the most relevant to the task force members.
Thank you.
Yeah, great. So we have it pulled up, so we will get started. And I definitely echo Professor Konkar's remarks. We definitely want to hear from you all which issues you think are important, and are happy to share our experiences.
So I think we just wanted to start a little bit. I think most folks kind of know what the Women's Prison Project is, but we did want to sort of start by talking about it. So the Women's Prison Project is focused on representing incarcerated women in Louisiana who are incarcerated for reasons associated with their abuse. At this point, the vast majority of our cases involve women who are serving life or long sentences for having killed abusive partners and acting in self-defense. But we recognize that there's a whole broad category of criminalized survivors who, because, as my husband, Marcus Konkar, talked about at our last task force meeting, we know that intimate partner violence and trauma and abuse is the most pervasive pathway to prison for women. And so, we don't want to limit the discussion today to only those cases involving self-defense, but because there are so many currently incarcerated women, many of whom have been incarcerated for decades, it's certainly going to be something that we'll talk about a fair amount today. Historically, the program that I run, the Domestic Violence Clinic, for about 2 decades, we've been providing civil legal services to survivors of intimate partner violence, working with survivors, in concert with prosecutors, trying to help keep them safe and through whatever mechanisms would make them most safe. But one of the things that we realized over time is that it's certainly not a black and white issue where our clients are presenting interacting with the criminal justice system exclusively as victims, but they also interact with the criminal justice system as defendants. And it's quite common. And so one of the missions of this project is sort of to, break down those sort of black and white conceptions of who's a victim and who's a defendant, and to sort of add some nuance to that conversation. We have a photograph here of some of the women who our project has worked with and represented. As you might notice, Sandra is featured here. Sandra has very generously encouraged us to use her story as an example of what goes wrong in these cases throughout the criminal justice system. And Sandra served 25 years of a life sentence, a life without parole sentence, for killing her abusive former partner while she was defending herself in her own separate home. Beatrice, who is also pictured here, the lady with gray hair, she served almost 25 years of a life without parole sentence, also for defending herself in her own separate home against her former abusive partner. These are just two stories. I don't know, Stas, if you want to take a minute to talk about the other stories.
Yeah, so down on the bottom, that's Betty Jean Broaden. And Ms. Broaden served over 37 years after an acquaintance of hers entered her home and sexually assaulted her at gunpoint. And Ms. Broaden was convicted of killing this gentleman. And last year, after reviewing the case together with the district attorney's office in the parish where she was, they agreed to her release, and she was exonerated. And then on the very right, that's Candace Malone, who was a college student when her abusive boyfriend started strangling her and attacking her. And it eventually led to a situation where she was trying to leave her home, and he was trying to stop her, and she was convicted for killing him in that situation. And Ms. Malone did over 13 years and just came home earlier this year as well.
And I'll just take a moment to say that, these are just sort of, brief snapshots of the experiences of a few of the women who we have and are representing. But one of the things we learned once the Women's Prison Project got up and running is that the number of women who are currently incarcerated in LCIW who have cases that would fit the project's criteria in terms of they are incarcerated for reasons associated with their abuse and even specifically associated with having killed an abusive partner in self-defense. There are more of those cases more of those women than we can, as a project, can ever handle. And that is why, and we've reviewed hundreds of cases. I personally have reviewed most of the cases of most women serving life and long sentences in state custody. And so we're really excited about the work of this task force because we can't reach all these people. Our project has limited resources, but probably more resources than anybody else to really dig deep in these cases. But it takes a tremendous amount of work, and we really need to figure out how to reach these women. How are we going to fix these injustices? And we can't accomplish it on a case-by-case basis through our project alone. So I think today we've kind of already covered this, but we're going to talk primarily about women who are already incarcerated, who are survivors of intimate partner violence. And we're going to talk about that nexus in the criminal justice system and sort of what goes wrong in these cases, why they end up wrongfully convicted or with excessive sentences that are far disproportionate to their actual culpability. So we put this graphic up here because we wanted to just basically start with the idea that, the failures that we see are happening at every level and they build upon each other. So it's not a problem of policing or prosecution or pardon and parole or sentencing. It is there are problems at every level that are contributing factors to these unjust incarcerations. And so, we sort of have highlighted here some of the various stages where we see things go wrong and we see patterns over and over again. And one of the things that's important to recognize is once it goes wrong at one stage, that it snowballs, right? And so at each stage, they rely on the things that went wrong at the stage before it, and it sort of builds up and really dramatically increases the chances of wrongful conviction. I'm going to start for a minute to talk about the police response. And although it's not something that we're going to focus on today, largely because, from our perspective, there's a lot of impact to be made in other areas. But as we know, we, as a society, really have framed intimate partner violence as a criminal justice problem and kind of dumped the problem almost wholly in the hands of our local police departments, right, to fix it and address it. And one of the problems we see at this level is that victims are interacting, survivors are interacting with the system as both victims and defendants. And we have a legal system that really only addresses intimate partner violence or domestic violence through the lens of a single incident, right? So when somebody gets charged with intimate partner violence, they're getting charged with, domestic abuse battery related to one single incident. And what we see over and over again in these cases is that when police are charged with coming in, the responsibility of coming into a domestic call, and their job is to figure out what happened in this incident. It's really, really hard to contextualize what happened, right? Because it takes a single incident out of context, and it takes out of context the ways and the circumstances under which women are sort of left to use force or violence to protect themselves in the context of abusive relationships. We also do see that many of these cases snowballed as a result of a dual arrest or a wrongful arrest, where a victim may have called for assistance and both parties were arrested, or one person was arrested. And then, of course, that arrest then becomes relied upon in making future decisions. We have seen, not just in Louisiana, but everywhere, that, some of our mandatory arrest statutes, have disproportionately affected women of color in terms of them being more likely to be arrested in response to calling for assistance in response to abuse. And we just see a lot of issues with the designate with, determining like not who hit who first, but who presents a danger to who is the predominant aggressor here. And a lot of sort of cultural myths around the idea that, there's mutual violence, right? So if a survivor of intimate partner violence does anything to defend herself, or uses force or violence in the context of that relationship, it's perceived as mutual violence, when in fact, only one person presents a danger to the other. And that really connects to a concept that we're going to talk about a little bit later, which is sort of the concept of a good victim, right? And who deserves to be protected, who meets this cultural stereotype we have about a victim of domestic violence who's sort of cowering in the corner and never fights back. Which, of course, if we think about it in any other context, is a totally abnormal response to violence, right? The vast majority of people respond to violence by defending themselves or by fighting back. So I think one of the things just as we move on here to recognize is that, I think it's pretty clear at this point that we're not going to train our way out of this problem by training law enforcement. What we really need is to make sure that we have laws in place that really sort of reduce the impact that, one bad decision by, one officer or one prosecutor or one defense attorney, or, reduce the impact of that one person. And so I think for purposes of thinking about what the task force can do, we have to go further down the line to really think about what's going wrong at these other stages. Stas, I feel like I've been talking for a long time. Do you want to talk a little bit about prosecutors and defense attorneys, or do you want me to do that?
Yeah, I could talk about that. I think often we see, prosecutors have screening decisions that they need to make in cases they have to fully evaluate. And so a lot of the same sort of conceptions of domestic violence that the police are relying on, viewing it more as a single incident as opposed to looking at the broader perspective to understand who really posed a threat to who. A lot of those same issues apply to prosecutors and quite frankly to defense attorneys as well. I think one thing that we found is that just societal ideas about intimate partner violence permeate every stage of this, and even folks whose job it is to defend and represent women who are in these situations can be subject to the same stereotypes and myths, which make it really hard to mount an effective defense. And I say this coming to this as a defense attorney, and I can really think about how I represented clients in years past in these sort of situations, and I would do it a lot differently, after having a better understanding of intimate partner violence. And I think, those ideas, a lot of the same ideas sort of are prominent in the minds of judges and jurors. A lot of societal myths about intimate partner violence are. And I think we're going to kind of talk about how some law, we're going to talk about in a little bit, how some recent case law can mitigate that, and also some sort of possible legislative fixes to, as Professor Konkar said, reduce the impact of actors who may not fully have a good understanding of the dynamics of intimate partner violence and how it can lead to wrongful prosecutions.
Yeah, and so just really quickly.
I'm sorry, so go back.
Yeah, so really quickly, I think just in terms of judges and jurors, I think that Stas covered that. The same sort of problems, permeate throughout in terms of misconceptions about intimate partner violence. I don't know if you want to give the example of one of the cases that we, with our clients. Do you want to talk a little bit about the jury selection? What happened in that case?
Yeah, for one of our clients who was actually featured in the very beginning when we had the photos, they were doing jury selection, and this wasn't that long. It was I think a little over 20 years ago, and the attorneys were doing voir dire, asking if it's ever justifiable to hit a woman, and one of the jurors said, well, a nagging wife, I could see you being able to hit her just a bit. And that person actually ended up making it on the jury.
And became
may have even been the foreperson. Yeah.
Became the foreperson of the of her jury.
And so that's, yeah. And I don't obviously I'd like to think we've made at least a little bit of progress in people's attitudes about intimate partner violence since then, but I think a lot of the same ideas are still really prominent on juries today, and we need to be thinking about that.
Yeah, and I might as well also point out at this point that the vast majority of these cases that we've reviewed involve non-unanimous juries. which, in and of itself suggests that there are mitigating circumstances that really weren't taken into account under our mandatory sentencing scheme. So on the next 2 points, sentencing and post-conviction, we're gonna save those to talk about because we're gonna do more with that because we actually think that it's useful to explore those in a little more detail in terms of some of the legal issues that are that could make a difference in remedying some of these issues. And then, of course, we've got this sort of at the very end of the process, we have this possibility of pardon and parole. And so, what we see here is that the vast majority of women who have these types of issues are going to be, representing themselves in pardon and parole hearings and are going to be in a situation where it is almost impossible while representing themselves to both explain the role that the intimate partner of violence had in their trajectory to prison and to also accept responsibility in ways that are expected of them through that process, right? Because it can look like an excuse, it can look like not accepting responsibility, and of course accepting responsibility in and of itself can be a harm for somebody who's truly a victim of trauma and intimate partner violence when you ask them to accept responsibility for something that happened in a context where they didn't have any meaningful choice. And so we'll talk a little bit about that process a little bit later a little bit later in the session.
Becky and Stas, real quick, I'm not sure if you wanted to address questions as y'all go. There's a question in the chat specifically about police reports. So if you want to address that before you move on to the next session, or we can do it at the end.
Thank you. Let me see what the question is.
How can we address police reports where the woman is in a DV relationship, but the police report names her as the aggressor?
Yeah. Well, I think that's a good question. Certainly, there are a lot of situations where the police will make a determination of who the aggressor is, and we think that it's not fully informed by the dynamics of intimate partner violence. Louisiana does have a predominant aggressor law that requires police officers to take into account a number of different factors, including prior history, what the status is with the children. But police officers are human beings and don't always get that right. And we find that especially in homicide cases, which are mostly the cases that we deal with, the homicide detectives don't get the same training as the detectives or as the police officers that work on domestic violence cases. And so it is definitely a problem that survivors are often mislabeled as aggressors, and it's up to us to work at every stage of that to make sure that as little harm is done as possible. Do we want to? Thank you for the question. Do we want to go to the next slide?
Yeah, I think so. So in terms of sort of what goes wrong in these cases, we think it's there's a lot going on right now in the news and around the country around issues of self-defense and who can claim self-defense, and this is actually a huge issue here. And so I think that it's worth having a conversation about, because at least for this category of cases, which is not insignificant in terms of the percentage of women in Louisiana who are serving life or long sentences, our self-defense laws it's important for us to look at them. It's important for us to have a sense of what's going wrong. So if you think about, self-defense is basically the same anywhere. So it's not specific to Louisiana, except for the fact that maybe not all states have such a pure stand your ground defense available to folks. But generally, it's going to be the same anywhere, where basically the rule is that you have to show that you have acted reasonably in response to what would be considered an imminent threat of great bodily harm or death. And so this really breaks down into sort of 3 categories. And I want to talk a little bit about like what happens in these cases, because basically the self-defense laws that we have were clearly not designed to be applied in the context of intimate partner violence. They were really designed to be applied in the context of 2 men who are kind of brawling in a bar, or, you know, something of that nature. And we see over and over again that they're just not working in these cases. So when we talk about the concept of reasonableness under the law, it's really an objective test. And so the test is not whether that survivor of intimate partner violence actually feared imminent death or serious bodily injury, but whether it was reasonable for her to feel that way. And so you can imagine the challenges that presents, you know, where an outside observer would not have a clear understanding of the full context in which a survivor is determining that she is fearing from imminent death or serious bodily injury. And so I think that, you know, one of the more common places we've sort of seen this is in many of these cases, there is a history of strangulation where the survivor had been repeatedly strangled, and that led that survivor to believe that there was to reasonably conclude that any incident of intimate partner violence could result in death or serious bodily injury, because it takes such a short period of time to kill somebody through strangulation. And we know that repeated strangulations in the context of an intimate partner relationship dramatically increases the risk that survivor might ultimately be killed by her abusive partner. So the reasonableness standard and the way it is not designed to really inquire into, did she believe this? Was it actual fear, but rather would somebody else have the same fear, is a problem. In terms of imminence is really where I think about so many of these cases going wrong. So what the law requires is that the person who's defending themselves is acting in response to imminent danger, right? And it's treated under the law as like an instantaneous choice. Like in that second in time, there was something happening that made them think that this person was about to kill them. And it doesn't account for the fact that when someone is living in the context of chronic abuse, chronic physical violence, chronic emotional abuse, regulation of their daily activities, and all the control that comes with this and the violence, that they are literally living in a climate of imminence, right? Where the abusive party, one of the abusive party's tactics is to make them feel that they could be in danger at any moment, because that's an incredibly powerful control tactic, right? To make them believe that you don't know what's coming next, you don't know what to expect. So that climate of imminence, which is heightened dramatically by things like a history of prior strangulations, that climate of imminence might give rise to a very legitimate fear of imminent death or serious bodily injury that the law would not recognize, because it's not him holding a gun to her head, or pointing a gun at her, or something of that nature. So this is where you also see the cases that we where a victim of intimate partner violence is much more likely to find themselves in a situation where they have killed an intimate partner during a lull in the violence, because that is when it is safe for them to escape, right? So this is where you see the cases where somebody killed an abusive partner while they were sleeping, because he promised he would track her down. In fact, probably would have tracked her down had she tried to escape, and that was her escape. And of course, the parallel you can draw here is where you have somebody as a prisoner of war or being held in hostage conditions. If they were to take advantage of the person who's guarding them and torturing them falling asleep, and shooting them as they go out the door so that the person can't, chase them down and capture them. Of course, that person would be hailed as a hero who escaped abuse. But we don't have a parallel sort of rationale here when victims act, during a lull in the violence. And of course, that's much more likely to happen in a context where you have a serious physical power imbalance, right? Where, which is common in heterosexual relationships where the man is physically much more, much stronger than the woman. And then finally, I'll just briefly mention proportionality. So the response to the violence has to be considered proportionate. And so, what we see over and over again is situations where, because the abusive party ultimately had the most significant injury, and in these cases death, but there are other cases where people are charged with aggravated battery or whatever, because the abusive party had the most significant injury, the defense is considered not proportionate. And this is a problem that's very specific to women. Because of the power imbalance in relationships, women are much more likely to have to pick up a knife or a gun or something along the lines of an equalizing weapon, which will equalize that power imbalance, right? Because the vast majority of women would not be able to actually use the strength of their hands to prevent a strangulation, right? And so that's where you see these equalizing weapons, and you see victims getting charged because they've used weapons. And a very, very high percentage of these cases involve a single stab wound to the chest, which is not indicative of any kind of, pre-planning of any nature. It's indicative of, mostly panic near a kitchen, right? And trying to prevent a battery. So, Sas, I don't know if you want to say anything else about those before we kind of move on.
No, I think you covered it well.
Yeah, and then I would just say, the stand your ground laws, what we've seen, and two of the examples we gave when we started off, there is no obligation under Louisiana law that a woman flee her own home, right, in response to intimate partner violence. But we have not seen any examples of these cases where where a person's right to stand their ground in their own home has actually been invoked on behalf of the victims. When we talk about problems with some of the defenses in these cases, and a significant number of these women were defending themselves in their own homes. And what you see even in appellate decisions is references to the fact that she could have tried to crawl out of a window, or she could have tried to run out the back door, or she could have tried to escape in some way that the law doesn't actually require of somebody in their own home. And so I would also just point out here, one of the issues with this is that, we really do impose this idea of like victims leaving or fleeing. But what a lot of these cases look like is they have ended the relationship, right? And they are in their own homes, and their abusive partners come back, right? Come and force themselves into their homes. And so it's not an issue of, is she leaving? Why does she stay? Very often it's like, how do you keep somebody like this out of your home and not have to defend yourself with lethal force?
Becky, I have a quick question.
Yeah.
Can you speak at all to if it is helpful in these cases for there to be like a repeated prior history of a survivor calling the police to say, like, I feel fear, if that's helpful or not? And then also maybe just talk a little bit about why a survivor might not be calling the police, so that record might not exist, even if it could have possibly been helpful to the defense, especially in the context of race and communities that don't feel comfortable calling the police for those things.
Right. Yeah. So I think that, obviously, when we're investigating cases, it's helpful. Anything that corroborates the fact that, this person is saying that there's this history of abusive behavior on behalf of the decedent is always helpful. I think what we found in many of our cases is that the defense attorneys didn't actually introduce that evidence, or that evidence was kept out in some way. But I also don't think it's definitive, because for the very reasons that you just talked about, what we also see is that very often these cases result in lethal violence after there has been a poor police response, right? Where the law enforcement or and I shouldn't always say poor, but in a police response that did not result in any protection for the victim, right? Which is hard, because if you're only charging somebody with a misdemeanor, I mean, it's questionable how much, protection that brings as well. So what happens is, if a survivor has had the experience with law enforcement of calling and them saying, well, if we come back, everybody's going to jail, right? Or calling and he has a scratch on his face because she scratched him while he was strangling her. So she gets arrested, or he has a bite mark on the inside of his elbow because he was choking her, but he has the injury. Those types of prior experiences with law enforcement really leave a lot of survivors to feel like they are on their own, right? Most women who end up incarcerated for these crimes are primary caregivers of children at the time they're incarcerated. They're going to be more risk averse. We also have seen numerous examples of women who can't or don't call the police because it is a threat to their housing assistance. They may be receiving housing assistance and threatened with eviction, if the police come out, or if, this person is considered an unauthorized tenant or something of that nature. So what you see is, and of course, I think you're referencing sort of in communities where there's a significant police presence, that doesn't necessarily translate into significant enforcement of domestic violence laws, right? And so, where people have bad experiences and there's a historic distrust, it's very likely you're going to see people feeling like they're on their own to defend themselves.
But if I could just add a couple things. I mean, it's certainly helpful when you're representing someone to have a documented history of calls to the police. We have clients now where there's a long documented history. I'm talking like 7, 8 calls to the police that were never introduced by the defense attorney because they weren't thinking about that sort of investigation, or because the judges aren't aware of the special rules of evidence, which there are some special rules of evidence for these sorts of cases in Louisiana Code of Evidence 404. And so now we're in a situation where there are women, we're uncovering all these records that were never presented, as we'll talk about later, there are some barriers to reopening those cases based on time limitations set up by Louisiana's post-conviction laws. And one other thing I'd say is sometimes we've seen situations where defense attorneys won't immediately find police records, so they won't go further and do the necessary life history interviews and talk to all the people who would have known if there was significant abuse. And it really takes a lot of time and resources to do that because it involves having a lot of difficult conversations about really sensitive areas of people's lives. But we've also seen, there are ways to show there's a prior history of abuse and someone's actions are reasonable without records. And unfortunately, we haven't seen a lot of trial attorneys, especially 10, 20 years go to those lengths.
Yeah, and so I'm going to sort of now highlight for you here some statements that were made in the closing argument in Sandras' case, because you can see how the prosecutor here is capturing all of those sort of issues that we talked about in terms of reasonableness and imminence and fear. So he's sort of speaking to what is the standard of self-defense here. And he says imminent danger of losing his life, meaning I'm fixing to die, people, or receiving great bodily harm, not an injury, or not I'm going to get slapped, or uh-oh, it might be a choking. So in Sandras' case, more than 5 witnesses had previously seen the decedent in this case strangle her. And you see here the prosecutor referring to a strangulation as not related to the possibility of a serious risk of imminent bodily harm, of great bodily harm. You see the prosecutor saying, no, you may not defend yourself just because you might get injured, right? Which is the same thing as saying, if you're, a 5 foot tall woman with a partner who's 6'4", and there's nothing you can do to prevent a physical battery, you cannot pick up an equalizing weapon to defend yourself against what would actually just maybe be, getting beaten up that day. Because the only way that would be possible is if you pick up a weapon. You can see the prosecutor goes on to basically critique that, if this person's never been to the hospital before, then surely there's no history of domestic violence. And of course, it would be extraordinarily rare for somebody to actually go to the hospital as a result of a strangulation in an intimate partner relationship, let alone all the other things which do in fact leave visible injuries. And so you can see how this type of argument sort of plays on all of those flaws in our self-defense laws and really make it almost impossible for a survivor to meet the standards that the law imposes. And Sandra, I so appreciate you being willing to let us sort of share your story in order to highlight some of these issues. And I wonder if now you might want to take a moment to sort of talk about what some of your experiences were in the criminal justice system, right? Like with your attorney, all those issues that we just walked through in terms of the various places in the process.
Sure. First of all, hello, how you all doing today? To me, looking back, the system did not hear my cry. They didn't help me at all. The police, I called the police several times. Every time they arrived, it was always men. So of course, my voice was useless. My voice was unheard. My cry was unheard. I called them so many times to where it got to the point to where when I would call them, on one occasion, they arrested me with him. I guess they thought that would solve it, but it continued. Like I say, the system failed me and the police didn't help me. I did everything I needed to do with filling out a restraining order, calling the police. I didn't even know that my neighbors, and I didn't even know they knew. I thought that nobody knew. I didn't even know I was a victim. Growing up, this was normal in my household. So if he didn't hit me, he didn't love me. So wrong. And then also, if you have questions, just jump in, because this is kind of like every time I redo this, it's like I'm reliving it, but I get stronger and stronger. So, and to whoever it helped, I'll tell it over and over again. As far as my cry, I feel like when I was going to court, my attorney, at first I felt that he had my best interest at heart, but he did not, because he came to me and said, you're going to get 30 years or you're going to walk. That was it. And with 2 small children at home, I wanted to get back to my kids, whatever. I went in there, life sentence was never on the table, ever. I sat in the courtroom and it was like I was invisible. I was in my own trial. I was invisible. My attorney never spoke up for me. They talked a lot about domestic violence. Like I said, I didn't even know I was a victim. So all of that was foreign to me. The prosecutor talked about my characters. Excuse me, someone said something? The prosecutor talked about my character as if he just humiliated me. So that was victimizing me again. And then my judge, he had other obligations. So my trial wasn't really of importance to him. I did not see a female until during my whole case was when I was going to my sentencing. That's when I saw a female.
Sandra,
My whole trial, court, everything. Yes.
when you say that you never saw a female, do you think that that had something to do with like?
I think a female
about
would have been,
trust, or what was the?
it was a lot trust, because I don't know, I felt like a female would understand. She would hear me, understand how I felt. I probably would have opened up more. But what was happening to me made me, I was just around men.
Sandra,
getting victimized.
Oh, I'm sorry. Can I ask, in your relationship with your defense lawyer, how much time did you spend with him? How much time did he talk to you about your?
Not a lot. Not a lot. He rarely, when he came, it was probably, it wasn't often. When it was time to go in the courtroom, or if he was coming to tell me they're putting my date off or something like that. But
So did he ever sit down and talk with you about your relationship, and go through with you and talk about the abuse that happened before?
I don't know. Actually, now that I'm looking back, I don't think he knew how. Just like I don't think the police knew how, when they came out, they didn't know how to address a domestic violence situation. I didn't even know I was a victim. The judge probably didn't even know how to handle a case like that. The attorney, the DA, nobody, I mean, domestic violence was unheard of.
Right.
Thank you, Sandra. We're gonna ask you to chime in a little bit later as well. Thank you.
Okay.
So I'm going to take just a quick moment. I don't want to run out of time. We have a lot of stuff we want to cover in terms of some of the legal issues here, but we thought it was worth noting that, you know, one of the problems we have here in these cases that we've seen over and over again is how the concept of battered women's syndrome has kind of permeated our thinking about intimate partner violence. And it's sort of premised on this idea that survivors of abuse sort of experience this phenomenon of learned helplessness, and that they're basically helpless to you know, they're not able to help themselves. They're passive, and it plays into this sort of good victim stereotype, which excludes the vast majority of women who actually, you know, do fight back, who do defend themselves, who, you know, defend their lives using force or violence. And what battered women's syndrome did, you know, historically, we thought of it as this like positive, progressive way of, you know, sort of taking domestic violence into account when a woman kills her abusive partner. But what it did is it basically, and it took it outside the realm of self-defense. She wasn't defending herself, but she was so emotionally distraught and flawed that her conduct should be excused, right? And it turned it from like a justification self-defense case into, let's just excuse her for acting badly because she's, you know, a little mentally off. So it has had this effect of sort of pathologizing survivors and making it sound like their responses to abuse are somehow irrational, when in fact, you know, if you really get down to it, in the vast majority of these cases, all of their conduct can be described in very, very rational terms. And so in terms of our advocacy with survivors, we really try to steer away from this concept of, you know, sort of, you know, women being irrational in the ways that they defend themselves, and really sort of trying to make more clear that they rationally acted in self-defense.
I'm going to talk a little bit about State v. Curley, which is probably the most significant case from the Louisiana Supreme Court about women who have defended themselves in domestic violence situations. So Curley is actually a case, the lady's name was Miss Katina Curley, and she went to trial, and there was for killing her abusive husband, and there was overwhelming evidence that he'd been abusive to her in the past, including numerous witnesses, police reports. But one thing that the defense attorney didn't do was the defense attorney didn't consult with an expert in intimate partner violence. Now, as Professor Konkar said, courts refer to that sort of expert as a battered women's syndrome expert, but the Louisiana Supreme Court has also recognized that language doesn't really is outdated and doesn't capture what we really mean when we talk about survivors killing in self-defense. So we're going to use the term intimate partner violence expert just for the rest of our presentation. But in the Curley case, the Supreme Court found the defense attorney was ineffective and ordered a new trial. And then Ms. Curley's attorneys consulted with experts in intimate partner violence after she was granted a new trial. She had another trial and she was acquitted, and now she's on the National Registry of Exonerations. And so a lot of folks have tried to make similar claims. And actually folks were trying to make similar claims to the ones that Ms. Curley made for decades before her case, arguing that their attorneys were ineffective for not consulting with an expert in intimate partner violence. But this was the first time that a Louisiana court recognized this claim as valid. I will note it's not actually particularly novel. There was a report from the Department of Justice in 1996 that talked about the importance of using these experts. But Curley was really the first time where the Supreme Court of Louisiana recognized that that was an essential part of representing women in these situations and all survivors in these situations, and that consulting with an expert was really necessary to ensure that survivors on trial for killing their abusers got a fair trial. And experts can address a number of issues. So they can address whether a survivor had a reasonable fear of imminent great bodily harm, taking into account how the history of intimate partner violence would have affected that determination for all the reasons that Professor Konkar mentioned earlier. And experts can also talk about the dynamics of intimate partner violence. So in so many of these cases, we see one of the main issues at trial, the survivor will have difficulty retelling what happened or won't remember the actual few seconds where the shooting happens or the stabbing happens. And that is often a key point that the prosecution makes for why the survivor is being untruthful about the events. Experts can tell us that in really traumatic situations like this, the brain isn't focused on memory as much as it is on responding in that particular moment. And that can make it really difficult to accurately remember and retell events later on. So experts can address issues like that. They can also address issues like, why a survivor, like a lot of times, something we commonly hear is, well, if he was so abusive, why didn't she leave the relationship? Or if he was so abusive, why did she drop the charges when he was arrested for domestic abuse battery? And I think a lot of folks just out in the community who don't have a background in intimate partner violence might be persuaded by that. They might think, if he was so dangerous, she would have left earlier, or she wouldn't have dropped the charges or bailed him out of jail. But an expert can explain, how the level of control that an abuser puts over survivors can make it really difficult to leave situations like that. And in many situations, survivors do leave the relationships. And by the time the homicide happens that they're on trial for, they've left the relationship multiple times. And so, we won't go into all the things that an expert can be helpful for, but it really is essential. And the Supreme Court has found that it's essential to have experts in order for survivors to get a fair trial in situations like this. Unfortunately, it has been very rare historically in Louisiana courts for defense attorneys to consult with experts in intimate partner violence. And Professor Konkar has reviewed over 100 cases of situations where intimate partner violence played a role, and it is very, very rare that defense attorneys consult with experts. And so one big issue in the law is the Curley decision. There's a big question about whether the Curley decision will apply to individuals who were convicted many years ago. Typically, you get 2 years to seek post-conviction relief after a conviction is final. And there are some exceptions to that. But so far, Louisiana courts haven't actually allowed Curley claims to proceed under any of the exceptions to this 2-year time limitation for seeking post-conviction relief. And that's a real challenge because, we can fix things moving forward and we can focus on better practices moving forward and better representation moving forward. But the most egregious cases of wrongful convictions are likely to be people who got convicted 10, 15, 20, 25 years ago. That's, longer ago that's when representation was probably at its weakest. That's when experts weren't as widely available and people weren't consulting with experts. And that's also when these sort of stereotypes were most pervasive. And so We're going to talk about this in a little bit, but there have been a number of, there's been legislation to make exceptions to this 2-year time window to seek post-conviction relief for other areas where there are very likely to be wrongful convictions. And that is one area that, could be an option to consider from this task force. Specifically, we wanted to bring up, so there was actually a factual innocence law passed this last legislative session, and that was a real step forward. It says legislative sessio, that there should be an N there. That is not a term of art or anything like that. So this legislation actually allows folks who, it expands who can overcome the typical 2-year time limitation for folks who don't have DNA evidence. So it expands who can make these sort of factual innocence claims. And it really recognizes that individuals who are wrongfully convicted might not fit into the neat categories set out by the time bar that we have so far in Code of Criminal Procedure, Article 930.8, and it's a real step forward that Louisiana has taken to make sure that people aren't wrongfully convicted. At the same time, certainly, I don't think it's entirely clear whether this law will apply to survivors who killed in self-defense, but the law doesn't appear to have been written primarily with those individuals in mind. And so, this one area of law is something I think we can hail as progress in terms of ensuring that folks can get into court if they've been wrongfully convicted. But one other area the task force could think about is meaningfully integrating these sort of situations where survivors killed in self-defense and their actions are justified and therefore they're innocent into legislation like this.
Yeah, if I could just piggyback on that. I mean, I think, that this is actually an important statute for us to look at as a task force. It is a good example of, progress in criminal justice reform and wanting to remedy past wrongs. But it's also an example of how easy it is to write a statute in a way that may not capture the types of claims that women have, right? Because there's so many fewer incarcerated women than men, and women tend not to have innocence claims associated with things like DNA, right? And so this statute doesn't explicitly capture the types of innocence claims our clients have. Of course, if you defended your life and acted in self-defense, you didn't commit a crime and you are in fact innocent. But we, not just in this statute, but throughout the law, have had trouble sort of recognizing innocence claims in a framework that would capture women's innocence claims.
So we primarily talked about self-defense cases, but there are other categories of cases where it's really important to take into account the dynamics of intimate partner violence. And one really significant area is situations where a survivor might play a minor role in the crime or might go along with an abuser to participate in a crime because of the dynamics, of course, of control and because of the pressure that's either implicit or explicit. The survivor has to participate in the crime with her abuser. And unfortunately, in Louisiana law, there aren't a lot of mechanisms to prevent women from those situations of being convicted, and they are actually under the law found equally culpable to the abusers that they accompany, which is a big issue. So, for example, there are cases where a abuser might be going to burglarize someone's house or commit a robbery and ask the survivor to come along, and because they've been together for years, because she's afraid of him, because she doesn't have a meaningful opportunity to leave that relationship, because she's been isolated from her friends and community, it's really difficult for survivors in that situation to say, no, I'm not going to go along with you to commit the crime. But we've seen situations where, women will go along to commit will go along with their abusers, play a very minor role, like in a robbery, maybe, be the driver or something like that. And then the crime turns violent, it can turn into a homicide, and all of a sudden, there are survivors who are charged with murder and facing a mandatory life without parole sentence in situations like that. Louisiana's principal law doesn't distinguish between people who have minor roles in crimes and major roles in crimes. And when someone's convicted of second-degree murder, there's only one sentence, life without parole. So women in situations like that can face real challenges because of these laws. We do have a duress law, but the duress law, and I typed it out here, I'm not going to go through it, but it really contemplates a sort of situation when there's a gun to someone's head and they're saying, commit this crime. That's not the typical situation in intimate partner violence dynamics. It's not, there's a gun to the person's head right now necessarily. It's, we've been together for 5 years during which the survivor has been conditioned to comply with the abuser's demands through a combination of force and manipulation. And by the time that they're actually participating in the crime, often an explicit threat isn't even necessary. And so the duress law doesn't really take that into account. And there's also no explicit law that allows for experts in intimate partner violence in situations like this. There is an explicit law in self-defense situations, but not in situations like this, where it's a duress situation. So I mentioned mandatory sentencing. It's important to note that Louisiana is only one of 2 states in the United States that requires a life without parole sentence for second-degree murder. And what we found is, a large number of women who killed their abusers are charged with and convicted of second-degree murder. And when that happens, judges don't have the discretion under the statute to give survivors lower sentences. It's also important to note that the second-degree murder statute in Louisiana is quite broad, so it doesn't make it so you don't have to have a specific intent to kill. You can be convicted of second-degree murder if you only have a specific intent to do great bodily harm, or if you are participating in a felony and someone dies as a result. So the general, very harsh sentencing for second-degree murder in Louisiana doesn't allow a lot of leeway for survivors who are convicted of that. Just for comparison, we looked at some other jurisdictions and saw what sort of sentences people got when they were convicted of homicide for killing their abusive partners. So in Minnesota, the first 2 cases, they're both cases where a woman killed her abusive partner. And there was a case in Minnesota, and this is in the late 80s. She was convicted of second-degree murder and got an 8.5-year sentence from the trial court. And the Court of Appeal actually reversed that sentence and said it was too harsh and sentenced her to 54 months. So that's a stark contrast to the mandatory life without parole sentence that a woman in Louisiana who kills her abuser would get. Similarly, in Washington, in '87, a woman was convicted of manslaughter. She got from 31 to 41 months, which was under the sentencing guidelines in Washington, and the appellate court reversed that conviction and said she should get a sentence of 90 days. In Louisiana, the sentencing range for manslaughter is 0 to 40 years. And there's also a firearms enhancement that prosecutors can file if it involves a gun, which could significantly raise the minimum sentence and not allow for anything close to 90 days. And federal courts too have recognized, when looking at the sentencing guidelines and deciding what sentences are appropriate, that an important mitigating factor to consider is what role the dynamics of intimate partner violence played in the case. So,
I just wanted to highlight. I mean, you've said this, but I just feel like it's really important to highlight that obviously, I think when Louisiana created a mandatory sentencing scheme, there wasn't this intent to capture this category of folks who are being charged under circumstances with extraordinarily mitigating circumstances, right? But, it's important to recognize that none of those mitigating circumstances in general can be, it's mostly just not part of these cases, right, in terms of determining culpability. So, I mean, that's sort of the cost, right, is that you're going to capture, you're going to equalize outcomes, but you're going to capture groups of people women are highly likely to have committed crimes in the context of mitigating circumstances associated with abuse, and none of those are going to be factored into sentencing.
Yeah, and what we see because of this is, defense attorneys representing survivors who get convicted of second-degree murder don't even offer mitigating evidence because the statute has this mandatory statutory sentence. We've seen in our cases that I don't think we've seen a single time where a defense attorney has even tried to offer mitigating evidence. And, that means the court system doesn't hear any of that. That means the judge doesn't have the ability to take that into account. And in a way, it silences these narratives of abuse and trauma in survivors who are prosecuted because of the mandatory sentencing laws. So that was our very quick, our very attempt at a very quick, I'm sure it feels long, overview of some of the issues in the legal system and some of the reasons that survivors are incarcerated right now, either wrongfully incarcerated or serving really long sentences. And so, we had wanted to brainstorm a little bit or start talking and imagining solutions, and we had some kind of ideas for areas of reform. And obviously that's something the task force is going to be looking into more thoroughly, but we just wanted to share our experiences with some of the challenges that women who are incarcerated have to getting relief.
Stas, but before you move on to that, can I ask, first of all, is there anyone who has questions about what
Please.
has been presented already? And maybe I will start with asking you to, you were talking about, of course, how often, how the rules about mandatory sentences and that there's only one sentence for second-degree homicide play into the injustice and the failure for the legal system to reflect culpability and proportionality. Do you see anything, can you talk about plea bargaining in this context, what we're seeing in plea bargaining when these cases come before courts and prosecutors?
Yes, definitely. Well, I think what we've seen is when there's a mandatory sentence of life without parole on the line, it means that people, folks who are charged with crimes are in a position where they feel a lot of pressure to take really, really long sentences just so they know that, can have that definite feeling of that I can come home one day. So when you're facing a mandatory life sentence, 30 or 40 years might be a plea bargain that someone would take. And I think one thing we've seen is that also, replicates a lot of the dynamics of abuse, right? That process in the court system, it in a lot of ways replicates the dynamics that survivors face. And it's not easy to feel empowered after you've been subjugated by your abuser for many years, and then someone is telling you, and maybe it's because they just don't understand the background, they don't understand the case. It's not always, people who are being malicious, but it's folks who might offer a plea deal of 20 or 30 years. I know Ms. Starr talked about it earlier, how her attorney told her, well, you can take 30 years, and her attorney told her that, he thought she could walk, but that's
Well,
a lot.
And I would point out the same thing also that Ms. Starr mentioned was that all the players were men, right? So again, you're talking about how it replicates the dynamics. You have powerful men who are exerting control over her life in the position as being judge, as position of being a prosecutor, as position of even being the defense lawyer, though someone who's supposed to represent and defend her, who might be saying to her, oh, you should take this deal because even though you acted in self-defense, you're likely to get life without parole. And
I think the data actually bears out that women are more likely to take plea deals for sentences, plea deals in general, because they're more risk averse. And of course, that means quite often it will be disproportionate to their culpability.
Yeah. I don't know if Ms. Starr, I think you're probably in a better position than we are to answer that question, what that felt like. I know you in a very difficult circumstance ultimately went to trial, but I don't know what it must have been like thinking about whether, you're going to take 30 years. Sorry, I didn't mean to put you on the spot. Just if you wanted to add to that.
I'm sorry. Oh, no, it's cutting in and out. I'm sorry. But
Oh,
I
okay.
did hear your question. When he offered the 30 years, it was 30 years.
Oh, Sandra, we lost you.
And
Oh, there you go.
when I was offered to think about, it made me feel like, say you're guilty and you get 30 years, and I was already in a vulnerable state. So I thought about my kids only, I mean, but I wasn't in my right mind to say, yeah, I did it. Give me the 30. I like I said, I didn't know the legal system. I didn't know the legal terms. I was a first offender. I thought he had my best interest at heart.
And I will say, I mean, that's an added challenge. There are women serving long sentences on manslaughter charges who took plea bargains. When you take a plea bargain, getting back into court is especially hard. So that's something maybe the task force will want to think about, ensuring that there's some mechanism even for women who decided to, or survivors in general who decided to take a plea under really difficult, often kind of coercive circumstances, to have some sort of relief.
Anyone else have any other questions about some of the things that Stas and Becky talked about? Well, then I don't want to interrupt your. I know you guys were going to make some suggestions about or thoughts about solutions. So I think we have a few more minutes left to tackle that.
Yeah, I think one thing, and Stas, I'll let you talk through some of this stuff, but one thing to, we sort of conceptualize this as front end relief and back end relief in the sense of like, so we have all these women who are serving life or long sentences around the issues that we've talked about today, who are already incarcerated. Things have already gone awry. And what do we do, right? How can we create some sort of relief valve for these folks who really never had a meaningful opportunity to raise these issues at trial or have these issues taken into consideration in their defense? And so we've sort of titled that sort of back end, like what do we do, with the folks that are already there? And then I think even more complicated than that is the issue of front end relief of like how can we build and support a legal system that prevents these injustices from happening in the first place. Anyway, so we sort of framed it that way. Stas, I don't know if you want to go through some of these.
Yeah, no, thanks for the framing and the overview. Yeah, so I think one kind of relatively simple thing is to just make explicit a provision that would allow for folks to make these curly claims without even if it's been more than 2 years since their conviction was final. That's generally been the mechanism by which our legislature has tried to protect people with wrongful convictions. We can see that with the factual innocence law that passed last legislative session. We can see that with the DNA law that allows for DNA that's presented long after the conviction to be brought to court. We can see that through the newly discovered evidence provision of our post-conviction time laws. And so one relatively, I think, simple, clean thing that could happen is just adding curly claims to the category of claims that folks can have some additional time to apply for relief for. This isn't something that would automatically result in the reversal of a conviction or anything like that. the claim would have to go to a court and the judge would have to actually determine whether the attorney was ineffective for not consulting with an expert. And the judge would actually have to determine if this prejudiced the petitioner. So it wouldn't be like substantively changing the law in any way. It would just be allowing people a little more time. And we think that this could be one way to ensure that, you know, survivors who got convicted 10, 15, 20 years ago, you know, in circumstances where their jurors might have just thought it was totally okay to hit their partner or strangle their partner. We think that that would at least have a bit of a mechanism for courts to look at some of these cases again. Another area, you know, we brought up the factual innocence law. There could similarly be a law that, or, you know, there could be some clarification added to that law that would allow survivors who killed in self-defense or participated in crimes under the duress of an abusive partner to get back into court and assert those claims. It similarly to the way someone would assert a claim that they're innocent because, you know, there was some bad scientific evidence that resulted in their conviction, or because there was DNA evidence that wasn't presented. There could be resentencing opportunities. You know, it's been happening on an ad hoc basis, I know in some parishes, but it would be good for there to be an actual mechanism that would create some process and procedure for survivors who are incarcerated to go before court and explain the full depth of the abuse and how it affected their actions, and give judges the power to take a look at that and really decide if they think it's appropriate to have a lower sentence in any.
And there are some states that have recently enacted laws that actually create resentencing opportunities for people who have these types of claims. And so I think there's stuff to be learned from them, but I think that's for another day.
Yeah, there are a number of examples, and
Yeah.
I think we'd be happy to follow up with the task force and present.
And then I would just point out also on the pardon and parole, I do think it's worth thinking about, you know, how can we enhance, you know, opportunities to raise these issues in the context of pardon and parole, and that there are some states who have specifically done that in ways that are helpful. But I think it's also incredibly important not to think of pardon and parole as like a panacea in a situation like this, because, you know, obviously it, you know, the process is largely designed, you know, for our community values around mercy and rehabilitation. And it's not as perfectly designed to deal with injustice, right? And so I do think that you don't want pardon and parole to be your primary mechanism to address injustice in the system. You don't want to wait until you get to that point. So we want to keep that obviously as an essential relief valve and think about issues around that, but we certainly wouldn't want to rely on that as like some sort of panacea.
Yeah, and I will say, I mean, I don't know if anyone saw, but that Mr. Homer Plessy received a posthumous pardon last week, and he was pardoned. He received a recommendation for a pardon, and that was under a specific provision that allows individuals to apply for a pardon who were convicted under laws that violated civil rights. So that was an example of a situation where someone can, and I'm sure Mr. Abbott can speak a lot more to this than I can, but that was an example of where an individual went, not because they've been rehabilitated or anything like that, but it was a recognition that the law they were convicted under was unjust. And so it's a bit of a different mechanism. But I saw Mr. Abbott, I saw you turn your screen on. I don't know if you want to add to that. But
No,
right.
I think you explained it perfectly. I've been hearing pardon and parole keep coming up. I said I better.
Right.
Well, we obviously don't want to have to wait for posthumous pardons here. So, but do any members of the task force have questions for Becky, for Stas, or for Sandra? And Sandra, I didn't know if you had a.
I think we also had one more.
Oh, I'm sorry. Please.
Yeah. So I think we'll just quickly address this. I mean, in terms of thinking through front end relief, which I think is way too much complexity really for us to dive into as a task force, given our time constraints, you know, really thinking about how do you adapt self-defense statutes to account for the ways that women tend to have to act in self-defense in the context of intimate partner violence, expanding, you know, defense and defenses of coercion and duress to also incorporate intimate partner violence, coercive control, making expert testimony explicitly admissible in other types of cases. And then just really kind of thinking about how can you create opportunities for sentencing deviation where, for example, you may not have an innocence claim based on self-defense, but you may have like significant mitigating circumstances that should speak to, you know, somebody's culpability and sentencing. And so anyway, there's some there are states doing interesting things around all of this. And, you know, maybe those are issues that we can visit at some point.
Thank you. So would now be a time to open it up for questions? I didn't want to cut you off again. Okay.
We have one more. No, I'm just kidding.
So again, I just want to open it up for if there are any questions from anyone.
I have a question for Sandra, and thank everyone for these presentations. This has been so informative. You know, I think prison is no place for survivors and doesn't offer, you know, the answers or support to folks who have experienced violence. And Sandra, I'm wondering, you know, what you would want to see reflected from this task force and the report of what support you would have liked, you know, many years ago when you were experiencing interpersonal violence, what you would have wanted to receive, you know, during the proceedings, and even now what supports you would like to see for yourself and others. I'm gonna
You're mute, Sandra.
ask to unmute you. There we go.
Should I let the scroll down now or just read ahead? I think that I can't get past the education part. People need to be educated about it, because how can you deal with a situation that you're either not, you're in denial about it yourself. You don't know how to deal with it, or you just plain don't want to be a part of it. You know, I think that the education about domestic violence, sexual trauma, all that need to be at the forefront. If I could ask for one thing, that's what I would want. I would want the education to go forth so that all those that I left behind, I'm sorry. All those I left behind will have that chance like I did. You know, they'll be able to trust somebody that's going to finally hear them, you know, because the whole trial situation, they weren't heard. And when the professors came, their approach was warming. They were female, which made me trust. And look where I'm at now. My cry's been heard. I'm living life. I lost a lot of it, but I'm here. So I think if I had to approach, and I do that today, if I see somebody, I will tell them or educate them about it. You know, and so that's what I think, from the police to the judge, to the system, to the courts. So if it was one thing, that would be it. It would help so many people that don't even recognize that they're a victim.
Thank you for sharing.
Thank you, Sandra. Thank you. Thank you, Sandra, and thank you, Becky and Stas, also for that presentation.
Thanks for having us.
So, I mean, I think obviously the importance and the powers of what we're thinking about and what we're considering and making suggestions about, it's pretty clear. It's people's lives. And so with that, I guess one of the things that we need to be thinking about as a task force is sort of taking, I think Sandra's call to action is number one, which is education, and figuring out ways that this task force can recommend that, you know, education be crucial. But of course we can't stop there. And so I guess one of the next item is to be sort of talking about what do we want to be recommending. I think Professor Morose and Professor Konkar gave us some really good ideas for us, what areas we want to suggest to the legislature that that they take, they consider future action in legislation. And if there's anyone else who has a suggestion, and actually let me pause a moment and sort of share one other thing, although it's a little out of line on the agenda, is I did want to say that because we missed a meeting due to the hurricane, I would like to set a meeting for December. And at that meeting, I'd like to, I've spoken with Sunny Funk, who is with the District Attorneys Association and who is a district attorney who would be able to speak and provide some perspectives about how prosecutors can address some of the concerns that were raised. Also, perhaps address issues like educating prosecutors so that they have better awareness. And then, you know, it certainly may be that we are prompted through that information that she can provide us with thinking about other legislative asks or recommendations that the task force might make as well. In addition, I think WPP would be able to also offer testimony at the December meeting to talk perhaps about what other states are doing in this area and what other kinds of legislations sort of along the line that that Stas and Becky mentioned at the end of their presentation. We might be able to present so the task force will have that as well, so that we can add those onto the suggestions of the task force to the legislature. So I just wanted to put those two flags in what might be happening in December, but open it up now for folks who might want to suggest any other sort of legislative recommendations beyond perhaps what we've heard from today. Well, certainly, I think one of the things that we will do is, you know, we will be drafting sort of a draft report and circulating that. Again, and this might happen in stages where next month's meeting, we would have some more information that might also inform any legislative recommendations that we make. And I would also encourage all the members, as you think about it and you sit with what you've heard today and what Sandras shared and what we learned from Professor Konkar last month as well. If you have ideas and thoughts, particularly coming from your particular field and position, please share them, email me and Katie, and we will, blend those in and present them as part of what the committee considers for recommendations at the next month's meeting.
Yeah, I just want to say, as a task force member, to enshrine in the notes, I really appreciate all the suggestions that y'all made, Professor Konkar and Professor Morose. And, I think there's a lot to consider about making the legislative recommendations, but I appreciate the ones that are rooted in things that the legislature has already done. And that would be more of an add-on rather than kind of reinventing the wheel, or just, like was said, the legislature has done things to address wrongful convictions and to address the wrongs of the past in the criminal justice system. And yet, women, and especially women who are survivors, are left out of that equation, even when action is taken. So making it explicit that this is a group of folks that need to be addressed, I think could be really meaningful.
Thanks. I also would just say, one of the reasons, we started talking about things that already exist is that, we just have such limited time. And I think one of the lessons that we can take away from some of the other states who have done stuff is that it's really important to take the time necessary to do something very comprehensive that really thinks through unintended consequences, and that sometimes it can do more harm than good to sort of address these things from a piecemeal approach, partly because then it feels like, oh, we're done, kind of thing. And so I would just put my 2 cents in there in terms of just being cautious about, rushing to, think that there's any one thing that's going to create a panacea.
I think definitely we want to make sure that it's very clear that this is a big issue that has a lot of fingers into all different parts of the system and isn't going to be fixed by just any one thing. And it can't be fixed by just legal action, right? I think as Sandra's points were well taken, is people have to understand, and it needs to be education at all levels. Well, I think the next item on the agenda is to talk about fiscal impact of any recommended methods and legislation. I think one of the clear fiscal impacts, of course, is if we can provide relief to incarcerated people who shouldn't be incarcerated, who are wrongfully incarcerated or over incarcerated. There's a fiscal benefit because we aren't incarcerating them anymore, right? So that certainly is clearly one of the fiscal impacts of legislation that we might recommend. I don't know if other folks have thoughts on what other fiscal impacts how this might extend into talking about the money component, which is part of the mandate that the task force is given, is to talk about how this would impact, have a fiscal impact. So again, I welcome any thoughts that people might have on that.
I would think that, having children remain with their biological parents for as long as possible would show us many financial impacts down the road, from education through emotional adjustment, not being traumatized by having your parent ripped away and put into prison, and there's a lot of social stigma around that too. It always makes you feel very different as a child when you know that your parent has entered the system. Just knowing that alone can be traumatic for a child. So I think that would be worth investigating and looking at all the ways that outcomes are generally better when children remain with their primary caregivers.
So that could even be something like generational costs, right? When we look
Right.
at, yeah. So it could be very broad and very long-term cost savings. In any other thoughts there along those lines? Because I think that's a real important one.
I would just add, Catherine, I'm sorry, this is.
No, definitely, yeah.
I would just add that definitely makes a lot of sense. The norm with kids with incarcerated parents is that eventually the kids become incarcerated.
Yeah.
Especially in Black and brown communities.
Well, and I think, yeah, I'm sorry, go ahead.
One of the things that was just striking to me is that I think I came to this epiphany when I had a interinstitutional visit with my son. It was in that moment, like the impact of me being in prison hit me. And it was also the moment I said, enough is enough. And so there's this thought with some kids that if they go to prison, then maybe they'll be with their parents.
Yeah.
Yeah.
And I think your point, Dolphinette, is so important because we've been talking about this with women, but it's not just, this doesn't just impact women, right? I mean, it's the whole family, and yeah.
Absolutely. And what we have seen system-wise, as we do this work and we do the research, the intent with systems and prisons in our communities was to take the man out of the home, but that did not tear that home down. It caused some issues in the home, but in most Black and brown families, the woman is the head of the household. She's forced to be that. And we carry that. And so because that home has not been destroyed by taking that man, the target became the woman. And we begin to see the rise in women being incarcerated. I did 12 years for shoplifting. And as we know, with shoplifting, you don't get the goods. They take that back, but you go to prison. And, that's not to justify. But in that moment, the options that I was given, I felt that was my option to take care of my kids, right? And so now the mother is gone. So who's left to target? The children. The grandmothers are raising the children. The grandmothers are tired. Most times they're old. And then we came up with these laws that would hold the guardian responsible for the children's actions. And then the cycle just continued. And so the cost savings, has levels.
Yeah, I mean, I think that's critical importance to make sure that we can explain that.
And when you think about what abuse looks like after leaving an abuser, a lot of times these abusers shirk all of their responsibilities, and that blame shifting behavior turns into, putting the financial burdens on the partner, the abused partner. So you see a lot of like deadbeat dads. And yeah, I mean, you become the person that's taking care of your children alone. And I'm speaking from my own personal experience with that. If something happened to me, just as Dolphinette said, grandparents raise the kids, probably. I don't have siblings. I don't have family down here. A lot of times abuse victims are isolated in that way too. I mean, so I think, you know, there's definitely high trends of that type of phenomenon of abusers continuing their abuse from far away by disengaging from the family, and putting a lot of financial and daily responsibility on the mom who was their victim.
I'm thinking about how, especially around the duress cases that were being talked about, and you know, especially the circumstances where the survivor, who was then charged as a principal, was, you know, just there and, you know, coerced into the crime. I'm definitely not suggesting we use the criminal legal system as a form of intervention, or like, you know, as a propulsion toward intervention. I do think there is this ability to look at the corollaries with human trafficking cases. We are like able as a society and a system to see people who are human trafficked, who, you know, in black and white terms would be looked at as committing a crime, but there are interventions made on their behalf to remove them from this abusive and violent situation. And I feel like with what we know about interpartner violence and how, you know, many survivors just need a couple $100s to get and stay safe, that is like a much lower cost barrier than the extreme costs of criminalization, prosecution, and incarceration. And if these folks are able to be identified at these moments of being a victim who is acting under duress, or, you know, is not a principal, that could be a way to, you know, reduce some of the emotional and financial burdens that we see from these cases.
Right.
This is maybe a little off topic, but just kind of responding a little bit to what Daphna and Rachel were saying. I mean, I do think that women's roles as primary caregivers of children is so significant, even to their trajectories, right? So when you have intimate partner violence, there's all this economic distress that comes with it, right? The economic distress of, you know, job instability and abusive partners not contributing to household income. And of course, those economic stressors also put people on trajectories. And the other really problematic aspect of this is that, you know, I sort of see over and over again survivors being criminalized because they are taking action to protect children from an abusive former partner, right? They go to his house to retrieve a child that he's refusing to return, and she gets arrested because she went to his house, or, you know, whatever it is. And so a lot of times that's sort of the entrance for some of these women into the criminal justice system as defendants. And then it forever sort of taints their record, you know, when there's any kind of law enforcement response. And so I do think that it is something we're not really thinking about as a community when we think about criminal justice issues, the extent to which women are primary caregivers and the extent to which it contributes to their criminal justice involvement. And of course, the implications of that, but in terms of the generational effects.
So keeping my eye on the clock, and knowing we need to make this, I just want to make a call to anyone in who might be joining us who's not on the task force, a public member who wants to contribute or say something, please feel free to do so. And again, anyone who is either a member of the task force or who is a member of the public is welcome and invited to contact me or Katie by email with any thoughts or contributions that you have. That would be great. We would welcome that. And yes, Katie just put her email in, and Katie, if you can, I can put mine in too. That would be. Mine in. Okay. Well, hearing no one, under the other business, I don't know if anyone else had any other business. I did want to just restate that we will set the next meeting, have a December meeting, because we did miss the October meeting from before, the September meeting. So the next meeting will be December 14th on the 21st. And I believe Sunny will come talk to us about prosecution. And then we also maybe have, we'll have someone from WPP can come share some other statutes from other jurisdictions that we can look to for models. Katie, do you have something else on that agenda?
We had said December 14th to not interfere with holiday time. I think that's what you said earlier too.
Yeah. Yeah, did I just misspeak? I meant December 14th. I apologize.
Yeah. I just wanted to be clear, and there'll be an invitation, and it'll be in the notes and everything. There was also an interest from some women from the Family Justice Center who have been arrested, not convicted and incarcerated, but arrested under mandatory arrest laws, who are possibly interested in coming to speak.
Great. Yeah, we probably will be able to make room for them as well, and it might fit well with the whole discussion about the prosecution of and how to proceed through the state's avenue. So, well, I'm like, I'm so impressed with myself. It's exactly 2:30. We are awesomely on time. I want to give a huge thank you to Professor Konkar, Professor Moroz for their presentation, and also a huge thank you to Sandra, who was so courageous, and so thank you so much for sharing your story with us. I think it really appreciate that a lot. Thank you. Thank you everyone for joining, and I hope everyone has a wonderful Thanksgiving. Take care.
You as well.